Mr. Glovic on behalf of the defendant. This is the plaintiff's motion for a temporary order. Ms. Jernigan.
Thank you, Your Honor. Just sort of some background. When I first was retained on this case, it was my understanding the parties had agreements, and I'm not going to disclose what those agreements were. So it was my understanding this was going to be a consent. I did have some communications with Christine, but explained to her over the phone that I could not represent two people. But if she had any questions or concerns about what I was drafting, she should hire an attorney to have them review any documents. So I did send opposing counsel a judgment for his review. But with that said, after filing, shortly thereafter, my client kept calling my office and there were several issues that kept coming up. It was like a pop, you know, the emotion where all of a sudden the anger and the animosity, and I think, to be perfectly quite frank, I think both parties have not probably been behaving quite well. But Your Honor, the problem is that my client works 2.5 hours away. Both parties are living in the home. My client's adult son, who's 18, lives in the home along with his elderly aunt, who's about 77 years of age. And the marriage has not been going well for the last couple of years. And if I can, I would like to show, and I haven't had the opportunity to show opposing counsel this because it was just prepared for me this morning. So there is a house and my client lives above the garage in an area. And then Christine lives in the house, and obviously he uses the kitchen and things like that. So there's no reason why the parties can't cohabitate and continue to reside together. So basically my motion was try to stop the bad emotions, the bad contacts, the bad discussions that have been going on with the parties, settle the waters, we'll exchange information and try to reach a mutual agreement. Now, I read opposing counsel's response. We don't have a lot of information of what's going on with the defendant's health. We just know what she's been telling my client, and it's kind of like this crazy speak. So apparently she's having a surgery at the end of this month. It appears it's going to be a double mastectomy. It makes sense then she could reside with her daughter. She babysits for her 3 grandchildren right now. It's my understanding Amanda lives very close to her, and she's been taking care of 3 children under the age of 3 while her daughter works every day. So she's having these surgeries. It makes sense that she resides with her daughter. She needs to recuperate, or she can stay in the home. My client's going to stay away and deal with his stuff. She can deal with her stuff. So basically I was saying he makes the house payment, she makes the utility payments. Again, there's a lot of communications back and forth that the defendant wasn't going to pay for her 2020 Chevrolet Traverse. It's her vehicle. It's my understanding my client's on the loan. That payment needs to continue to be made pursuant to the status quo. My client will continue to maintain all medical insurance as he's employed as a carpenter. He knows he has to maintain that medical insurance. And basically then I had the mutual restraining order on the dissipation of assets. Now, my client did tell me that the parties were talking about, one, selling the home and or Christine then would keep the home with some sort of payout to my client. So he has removed some of his personal properties, put it into storage. I have no problem disclosing what's been moved, what he took, but he's adamant that he has not touched any of Christine's stuff. So there was allegations that he's moved her clothes, her underwear, personal papers. He said that all of her passwords and everything, all her personal documents are left and he hasn't touched them. So only the two know what's been going on. Excuse me. I do know the police have been to the home and I want to stop that. I don't want any PPOs issued. I don't want like that eviction to happen. I think the two need to stop what they're saying to each other. And then we just go forward, disclose the financial information and go from there. So if she decides she wants to sell the house, we can sell it. If she decides she wants to keep the house, she can have the house. We just need to figure out what's going to happen here. But until that happens, my client doesn't have a place to go. Like I said, he works 2.5 hours away, gets up at 3 a.m. He comes back late at night. And then we're displacing 3 people as opposed to just 1 person. And the house is a lot of upkeep. There's 4 acres. My client stays all weekend. He's maintaining it, working on the home, keeping it, you know, presentable. So We're just asking that they reside together peacefully. If she doesn't want to stay, she can move in with her daughters and go forward and exchange information. So I'm just trying to calm the waters here.
Mr. Glovic.
Yes. Well, just to organize the two issues, what we're dealing with is an MRO and I guess competing requests for exclusive use of the marital home. Regarding the MRO, there's no dispute. Nothing should be moved. That's our position. My client has not missed any bills. There's no evidence that she has because she indeed has not. She's been paying everything as she always has. But it's not a problem now, but requesting an MRO, plaintiff already moved most of his stuff out to an unknown location. That was just represented by opposing counsel during her opening argument. And contrary to the argument, he did also move out all of my client's clothes, her underwear, her personal documents, marriage certificates, birth certificate, other vital documents, and we still don't have those back. And he did take those. My client will testify that he took those, and it appears that he probably destroyed them because at some point he just slapped $100 on the table and told my client to use that to replace her clothes. So it's really interesting that an MRO is requested now after he's already taken all her stuff and moved all of his stuff to some unknown location, presumably a location closer to his work, which is apparently 2.5 hours away. And so not only do we concur that we want a status quo order, we'd like a status quo order that has retroactive effect to several weeks ago before he took all of my client's clothes and underwear and vital documents. Regarding the exclusive use, my client is indeed scheduled to endure a double mastectomy to treat her cancer in less than 2 weeks from now. And the misrepresentation in the opposing side's motion that this was some sort of elective or even perhaps cosmetic surgery was just disgusting. I mean, she's enduring a life-saving surgery, and following that surgery, she's going to need a peaceful home to stay and recover at. And that's not possible with plaintiff there. The man who stole all her clothes and underwear and documents and who follows her around the house yelling at her, telling her that he hates her, that he hopes she dies. And if he does indeed work 2.5 hours away, why doesn't he want to live closer to work? Regarding his adult son, he could stay there. He's independent. And regarding his other relative, my client's the only one who takes care of her. She can stay too. So we're not really displacing anybody. I don't know where he took his stuff. Wherever he took his stuff, I imagine he could live there. Hopefully it's closer to his work, which is 2.5 hours away. So I agree with opposing counsel that we really do need to start moving on to property and see if we can figure out where we agree and where we don't agree and get these parties divorced. But in the meantime, I also agree that we need an MRO, that nobody's moving anything. I'd like it retroactively effective so that my client can get her clothes back. But I think we also need exclusive use, which really shouldn't be controversial if the opposing side has already moved all his stuff out and works 2.5 hours away. I think that's going to put the parties in a better position to communicate only through counsel and to actually resolve this divorce.
All right, thank you. It makes sense to the court that Ms. Douglas have exclusive use of the marital home, given the location of Mr. Douglas's work. As far as the mutual restraining order, I'm hearing an agreement. The court can't make that retroactive, but the court can order and will order that an inventory be done, a list of everything that Mr. Douglas took out, a list from Ms. Douglas of the things, itemized list of the items of clothing, the documents, all of that that Mr. Douglas allegedly took. And then that will give the attorneys and the court something to work from to figure this out. But it's clear to the court at this point that the parties do need to be physically separated for everyone's best interest.
Your Honor, if I may, opposing counsel didn't have a motion for exclusive use, and then the court doesn't have jurisdiction over the adult 18-year-old or the aunt. And that's kind of where I was trying to say this house is big enough to house 2 people.
I've made my ruling, and in his response, he does ask for exclusive use. So I'm treating that as a counter motion for temporary order. And I'm not ordering those other 2 people out, and particularly since Ms. Douglas is agreeing that they can stay. I'm just ordering him out.
So what's my client's time frame on that, Your Honor, with all due respect? Like, what do we have here? Because he has to find, he doesn't have a place to stay. He doesn't, so,
Okay, well, I would say 14 days.
okay. Thank you,
Your Honor, may I draft an order to that effect and submit it under the 7-day rule?
Yes.
I
And you
also
can,
have,
you
sorry,
can,
I
you
have
can
another.
email it. Hold
I
on, start again. You can email that to my clerk, Ms. Van Oler. All right,
I,
no, go ahead, Ms. Jernigan.
who is to make the house payment, Your Honor? We have a mutual restraining order, but who's to make the house payment then if she's having exclusive use?
My client already is, and she will continue.
So she'll continue
Okay.
house payment? Okay.
Yep.
All right. Thank you. I'm sorry, I just wanted.
No, that's fine. I know. It's much better to clarify things now than to have to come back later.
Correct.
Any other clarifications we need?
I take it she's gonna continue to make her car payment.
We
I
agree.
meant, okay, all right.
Okay.
We agree. I observe that as part of the status quo. We want the status quo. Both parties agree.
Okay. Thank you,
And,
Your
and the
Honor.
court is also ordering status quo financially.
Okay. All right.
Okay.
All right. Thank you, Your Honor.
All right. Thank you. We're adjourned. This is the matter of Sklonk versus Sklonk. Case number 2406801 DM. Present in the virtual courtroom, we have the defendant, Mr. Sklonk. We have Courtney Quist, attorney for plaintiff, and Nancy Ballast, attorney for defendant. We're here on the defendant's motion to enter the judgment. And Ms. Ballast.
Good morning. I'm standing by my requested relief. I have nothing further to add. I see there was a response filed, and I'll let Attorney Quist address that.
Okay. Ms. Quist.
Now that I did not expect. Your Honor, I made requested changes to Ms. Ballast, to the judgment for Ms. Ballast yesterday. I don't know if she didn't like the changes. They're supposed to divide the tax returns. So I asked her, what does she want it to say? I'll make the change. But she refused to answer, and said that you would do the math, but I don't think that's a good use of this court's time. The parties were supposed to.
I'm not particularly great at math either, so.
Yeah, exactly. And I think it got a little murky because the mediation agreement, and Mary Benedict did a great job, but Mr. Scalance is supposed to pay 75% of the household bills pending the entry of the UCSO. And as you can probably imagine, when you do a percentage for household bills and what they are, and they change every month, I think the parties have a fundamental disagreement about what that amount is. We addressed that in a status conference about a month ago. And you stated he's supposed to pay what he's supposed to pay under the mediation agreement, and they're supposed to split the tax return. Well, according to my client, the household bills are $30,745. His 75% would have been $23,059. He's paid $18,200, which leaves $4,859 owed. Well, the tax return, that's about half the tax return. So my suggestion is we do a set-off. I made the changes that Ms. Ballast wanted to the judgment of divorce. We sent it over this morning. The UCSO is updated. It's dated the date upon entry of the judgment. I'm just asking if they can't agree, set it for a 30-minute hearing so they can testify about the household bills. But I honestly think the attorneys should be able to do a set-off with simple math, as long as I have a calculator. I can do it. But I know I'm not that good with math. But I do think it's something that we can do together. In the judgment, I made all the changes Ms. Ballast wanted. If
Ms.
she
Ballast?
doesn't like them, tell me.
Good morning again. Thank you. On my information, my client has paid 75% of the household bills. And in Courtney's response, she says things were late, things were unpaid. Well, he hasn't lived in the home for a significant number of months. And if Heather is late in making payments, that's not on my client. We did provide, after that last status conference, another transfer of a bonus to Courtney's client. So we've done all the things that were required in the mediation agreement, and we know that Heather has filed a tax return, told us what the amounts are, and yet hasn't shared what she received back as a refund. So my request of relief was that she pay half of the refund to Paul, which is approximately $3,000, and then I'd be awarded an attorney fee because I don't get responses from Attorney Quist when I say this is a gentle reminder to send me these updates and or enter a judgment. I put in my motion the number of times I've contacted her since April, and we had initially placed statutory proofs on the record. And here we are almost 4.5 months later, and a deadline for entry of judgment has passed as of last week.
Your
Well,
Honor,
I'm just gonna, okay,
sorry.
go ahead.
I'm
Right.
so sorry. I'll second. Mr. Scalance is very focused on the bonuses, but he has not paid the bonuses he said he would under the mediation agreement. He did not pay 75% of the July 2024 bonus. He did not provide an accounting of the October 2024 bonus. He did pay the December bonus. He paid a portion of the April 2025 bonus, but we don't know what portion he paid. So he's very focused on what is coming to him. They are not focused at all about what he is supposed to do under the terms. And that's the frustration on this part. And when I say, in which I have said, what about the bonuses? What about the accounting? That's ignored. My resolution would be, why don't we just get together and sit down and figure it out? But you can't ignore, these are large sums of money in regard to his bonuses. They make up a portion of his income.
I'm going to set an evidentiary hearing. Unfortunately, it sounds like there's some factual disputes between the parties about the actual numbers, and both parties are gonna incur more attorney's fees.
I
But
agree.
that's how the court has to resolve these matters. So we will notify you as to when that date will be.
All right, thank you.
All right, we're adjourned. Thank you.